My name is Quinn, and I'm a student at the Indigenous Community Legal Clinic, also known as the ICLC in downtown Vancouver. This video has been recorded on the unceded ancestral territory of the Musqueam, Tsleil-Waututh, and Stolo Nations as part of the Live Law series on tenancy and housing. In these videos, we're going to talk about evictions under the Residential Tenancy Act, particularly how you can be evicted and by who. If you're not sure what the Residential Tenancy Act is, or whether the Residential Tenancy Act applies to your housing situation, I suggest that you first check out the coverage under the RTA video in this series. Keep in mind that even if your landlord says you don't fall under the Residential Tenancy Act, you should not take them at their word. They might be confused, they might be unaware of the law, or they might want to stop you from exercising your rights. If your housing does not fall under the RTA, you can contact the ICLC or the Law Students Legal Advice Program to learn more about your legal options. Now, let's start talking about evictions. Why can your landlord evict you? Under the Residential Tenancy Act, your landlord can't just evict you without a reason. The Residential Tenancy Act sets out the reasons that you can be evicted. Knowing these reasons is important because it affects how many days' notice your landlord is required to give you, how many days you have to dispute the eviction, and by when you need to move out. For more information on lawful reasons for eviction, check out the video in this series called Eviction Step by Step, the why and the when. Now that we've talked about why, let's talk about how your landlord can evict you. Let's pretend that your landlord has a lawful reason for evicting you. To do so legally, your landlord is required to follow certain steps. During this process, you will have several opportunities to challenge and maybe even stop the eviction. I'm going to go over these now. Step 1. Your landlord must serve you with a notice to end tenancy, known as an NTE, and this is basically an evictions notice. This means that your landlord must serve you with a written document that says they're ending your tenancy, basically that they're planning to evict you, and by what date you need to leave. Serving you with an eviction notice means that your landlord must deliver the notice to you. For example, your landlord can hand the notice to you, or an adult who lives with you, email you the notice if you've provided your landlord with your email, mail you the notice, or attach the notice to your door. Depending on how your landlord gives you that notice, it's considered to be received by you at different times. For example, if your landlord emails you the notice, even if you don't see or open the email, the notice will be considered received by you 3 days after your landlord sent it. Regardless of how your landlord delivers the notice to end tenancy to you, it's better to err on the side of caution and act right away. If you don't dispute the NTE within the required time frame or ask for an extension, then you're presumed to accept the eviction and there's nothing you can do to challenge it. Depending on the reason they're planning to evict you, your landlord will need to use a different notice form and give you the proper amount of notice, which can range from 10 days for something like non-payment of rent, or to 4 months for an eviction for landlord's use for renovation, demolition, conversion purposes, or something like that. For more than this, see the video in this series called Evictions, the why and the when. Step 2. Once you get an NTE, what happens next can play out in several ways. Scenario 1, you accept the NTE. Scenario 2, you try to negotiate with your landlord. Scenario 3, you dispute the notice to end tenancy by applying to the RTB. I'll say a bit more about each of these scenarios. Scenario 1, do nothing, accept the eviction, and move out. If you get a notice to end tenancy and do not dispute the notice, then you're presumed to accept the eviction and should move out by the effective date on the NTE. If you plan to move out earlier than that effective date, you should still give your landlord the proper 30 days notice if required. Scenario 2, negotiation. If you get an NTE, you could try negotiating directly with your landlord. Negotiation could help you and your landlord to find a solution that you both agree with and to keep you from going to the RTB. For example, you could try negotiating a later move-out date with your landlord than the effective date listed. Scenario 3, dispute the notice of eviction at the RTB. If you think your eviction is unfair or illegal, you can choose to dispute it by applying to the Residential Tenancy Branch for help. The Residential Tenancy Branch, also known as the RTB, is basically BC's tenant-landlord court. At the RTB, you don't need a lawyer, but it's still a good idea to have a representative, like a community legal advocate. Once you apply to the RTB, an oral hearing will be scheduled and will proceed by teleconference. The hearing process is similar to court. For example, evidence can be presented and witnesses can be called. The hearing will be run by an arbitrator. The arbitrator will hear both sides and then make a legally binding decision. To learn more about applying to the RTB, to challenge your eviction, check out the video in this series called The RTB. If the RTB decides in your favor, then your landlord can't evict you and the tenancy continues. If the RTB decides in favor of your landlord, then your landlord can continue with your eviction and will be given what's called an order of possession. Since the RTB arbitrator decides the effective date of the order of possession, meaning the date when you must leave the unit, and the date when your landlord can take possession of the unit, you can argue for a later date of possession and let the RTB arbitrator know how much time you need to move out and why. Let's pretend that your landlord gets that order of possession. This brings us to step 3. An order of possession is basically a document that the RTB gives to your landlord, which returns the right of possession to your landlord. Your landlord must serve this order of possession on you. The same serving rules that we discussed above apply. Remember that even if you don't open or see the order, it can still be considered received. Here's an example of an order of possession. Once you receive the order of possession from your landlord, or are considered to have received it, you must move out by the date stated in the order of possession. Usually, you'll have 48 hours to move out, but the timeline is decided by the arbitrator in each case. As soon as your landlord gets an order of possession, you should contact the Community Legal Assistance Society, known as CLAS, or the Tenant Resource and Advocacy Centre, known as TRAC. You may be able to apply for the BC Supreme Court for judicial review, or to the RTB for review consideration. You'll need to apply to the RTB for review, or to the court for judicial review, before the effective date stated on your order of possession. Since the effective date is often 48 hours, you'll need to act quite quickly. To be safe, you may also want to start looking for a new place to live. You might also want to gather and relocate any personal belongings like your medication or the things you need for work, because you wouldn't want these things to be removed from your unit by a bailiff if your eviction continues. We'll talk more about bailiffs soon. Note that you can't apply to the RTB for review consideration or the court for a judicial review just because you disagree with the arbitrator's decision. For both, there are certain grounds. For RTB review consideration, you will need to show that there is new evidence, that you could not attend the original RTB hearing because of unexpected circumstances outside of your control, or that there was some sort of fraud that took place in the original RTB decision. For judicial review by the court, there are also certain things that you'll need to show that will vary depending on the circumstances. If you don't apply for review consideration or judicial review, and you don't leave by the date stated on the order of possession, your landlord can't personally forcibly evict you. Only a court-appointed bailiff can forcibly remove you or your belongings. In order to hire a bailiff, your landlord would need to obtain what's called a writ of possession from the court. Your landlord can do this quite quickly. Your landlord just has to provide a sworn statement, an affidavit, to the court to say that they followed the proper process. Let's pretend that your landlord gets a writ of possession and you don't apply for review. This is step 4. Your landlord gets a writ of possession from the BC Supreme Court. What happens next? This brings us to step 5. A bailiff hired by your landlord comes to evict you. If the court gives your landlord a writ of possession, your landlord can hire a bailiff to enforce the eviction. Being evicted by a court bailiff is a stressful process. It means that you have no control over the timeline for your move, and sometimes even what happens to your stuff. A bailiff doesn't need to, and usually won't give you any notice that they're coming. They can just show up, physically remove you from the property, and remove your belongings. However, and this is very important, the bailiff must be court approved. This means that the bailiff company must be on the list of court-authorized bailiffs published by the BC Attorney General. Watch out, because there are people in BC who are paid money to pressure tenants to move out, even when they're not authorized to do so. For example, Vancouver Eviction Services is a non-authorized bailiff company that does not have legal authority to evict you, but falsely claims that they do. If a bailiff shows up at your door, and your landlord hasn't followed any of the steps that we just talked about, like giving you an eviction notice and getting an order of possession, then the bailiff and the eviction are probably unlawful. Here's the takeaway. If someone comes to your door claiming to be a bailiff, always ask for identification, including the name of the bailiff company. The ID should indicate that they're authorized by the Attorney General or the court. You can also look to see if that company is on the Attorney General's list of authorized bailiffs. You can access this list by going to the BC government website at gov.bc.ca, selecting Law, Crime and Justice from the menu, then selecting Courthouse Services, and then Court Bailiffs. If you're in Vancouver, there are currently only 3 bailiff companies who can be legally hired to evict you: Accurate Court Bailiff Services, Consolidated Civil Enforcement Limited, and Integrated Civil Enforcement. If the company's not on the list, remember, they can't lawfully evict you. You could call the police if you're comfortable, or if you prefer, contact the RTB or an advocacy organization like TRAC, the Tenants Resource and Advocacy Center. If the bailiff company is court approved, they can lawfully physically remove you from the property, change the locks, and remove your belongings. The bailiff may leave belongings that they assess to be of no value in the unit. The bailiff may also seize some of your belongings, and they may put some of your belongings in storage for safekeeping. You can usually then retrieve these belongings from storage, but you only get one chance. You need to pick up all your belongings from storage at once and can't make multiple trips. If your landlord does hire a court-approved bailiff to remove you and your belongings from the unit, keep in mind that you may be held responsible for some of the costs. If you are lawfully evicted and have nowhere to go, you could start by contacting First United by calling their 24-hour emergency shelter intake line at 604-839-6880. If you don't have access to a phone, First United's main office is located at 320 East Hastings Street. And now, for a quick recap. In this video, we've talked about what steps your landlord needs to take to legally evict you. Step 1. Your landlord serves you with a notice to end tenancy, also known as an eviction notice. Remember that your landlord must have a lawful reason for evicting you and must properly serve you with an eviction notice. Step 2. You may choose to dispute the notice to end tenancy, or try to negotiate with your landlord, or do nothing and accept the eviction. Step 3. If you don't move out by the deadline, your landlord can get an order of possession from the RTB and give it to you. If you dispute the NTE and are not successful, you would need to move out by the effective date of the order of possession. This is typically 48 hours. If you think the RTB made a serious mistake, you can apply for review consideration with the RTB or judicial review with the BC Supreme Court and dispute the decision. Step 4. If you don't dispute the decision or don't leave by the effective date, your landlord can get a writ of possession from the BC Supreme Court. Step 5. A bailiff hired by your landlord comes to force you and your belongings out of the rental unit. Keep in mind that all of these steps may not happen in your situation. For example, if you get an eviction notice, the process might end at step 1 for you if you accept the eviction and move out. As another example, remember that you can always dispute an eviction notice, and if you win, then you can keep living in your unit. If you dispute the eviction and lose, if you move out by the deadline, then your landlord won't need to get a writ of possession from the court and a bailiff won't come to evict you. This video was really just meant to give you a sense of what can happen so you can start to assess whether your eviction is lawful and know what to expect. To learn more about disputing an eviction, see part 2 of the eviction step-by-step video. If you're wondering if your eviction is lawful or want help disputing and challenging your eviction, we strongly recommend that you contact the Tenant Resource Advocacy Center, commonly known as TRAC. TRAC has a team of lawyers and legal advocates who can provide free legal representation to eligible tenants living in BC. You can start by calling TRAC's helpline at 604-255-0546 or 1-800-665-1185. To inquire about free representation at a RTB hearing, you can also contact Access Pro Bono's residential tenancy program at 1-877-762-6664, extension 1500. If you've already been to the RTB and lost and are now at risk of losing your housing, you can contact the Community Legal Assistance Society, CLASS, at 1-888-685-6222. The ICLC and the Law Students Legal Advice Program are also good resources. Thank you for watching.
All Live Law Project content is provided by law students for informational purposes only. It is not and should not be considered legal advice. We're not suggesting that you make legal decisions based on any content included as part of this project without seeking legal or other professional advice. We cannot guarantee the accuracy of our content. The information in this project may not apply to you if you don't live in British Columbia or if the law has changed.